All right, so we are about concluding the lecture. So I was trying to tell us the position of doubt, why the law uses the word doubt when we talk about proof beyond reasonable doubt. It simply means that even if there will be a doubt, let that doubt not be on any of the elements that is required to be proven. I gave us the example of Mr. John, who took somebody's bicycle. He was caught. He has admitted he took the bicycle and without permission. But one thing is still remaining. In a case scenario like this, you discover that the prosecution has been able to prove that a bicycle was taken away, and that bicycle was taken away without the consent of the owner, and that bicycle was taken by Mr. John. Now, Mr. John, in his defense, is telling the court that he took the bicycle because there was an emergency and there was no way he could meet up with the emergency situation. So he needed to borrow the bicycle and to return the bicycle much later. Now, you discover that all the elements of stealing have been proven by the prosecution, but minus one. What the prosecution has not been able to prove here is the element of what? The mental intent, the intention of Mr. John to permanently deprive the owner of the bicycle of the use of his bicycle. In other words, Mr. John is simply saying, I took this bicycle, but I did not intend to steal it. So if a judge listening to this and the judge believes him that there was no intention, then the judge will take it that the prosecution has not proved his case beyond reasonable doubt. But it's a different thing if there's evidence that John attempted to sell this bicycle to someone else. That in that case, the court will say, yes, the prosecution has proved his case beyond reasonable doubt. Even if John tries to change his story, I tried to, I was just joking when I said I wanted to try to sell the bicycle. The court would not believe that. All right. Now, what is the effect of having a doubt on fundamental element of an offense charge? When there is a doubt in proving any element of the offense charge, that doubt must be resolved in favor of the defendant. That means the defendant must be discharged and acquitted. See the case of Ojo against the state. Ojo against the state. Ojo against the state is reported 2018, 15 Nigerian Criminal Law Report, part 1643, page 527. In other words, this doubt must not relate to commission of crime. When there is a doubt as to whether this person committed a crime or not, that doubt must be resolved in his favor. In other words, after proving to show that the prosecution has proved his case beyond reasonable doubt, there must not be any probability that it might have been A that committed it instead of Mr. John. So when there is such probability, then the offense has not been proven beyond reasonable doubt. Again, where a piece of evidence is subject to double interpretations, where something that has happened can be interpreted in two ways. Maybe it could be he did it, it could not be, it could also be that he didn't do it. In other words, where there is no certainty pertaining to any element of the offense, then that is what? That is doubt. And that is the kind of doubt that we do what? We exculpate the defendant from commission of the crime. In other words, we can then say that the prosecution has failed to prove this case beyond reasonable doubt. Again, we can talk about when identity is an issue. If the identity of somebody who committed the offense is an issue, maybe we do not have, let's say, an eyewitness who was able to identify that it was Mr. John that did it, and somebody said, I saw Mr. John riding a bicycle, and Mr. John said, yes, I rode a bicycle. The bicycle is my uncle's bicycle. I took the bicycle back to my uncle, and maybe when the uncle is brought to testify. He said, yes, he borrowed my bicycle and brought it back. So where identity is an issue, it means that the prosecution has failed. When that identity issue is not resolved, it means that the prosecution has failed to prove his case beyond reasonable doubt. The same thing happens, applies to place of crime. Most of the times, place of crime. If the defendant cannot be placed to that place of crime, if there is no evidence linking the defendant to the place of crime, to the scene of the crime, or to the crime itself, then there is no way you can say that the prosecution has proved his case beyond reasonable doubt. Because it does what? It just leaves the judge with doubt. Even people who have come to witness the matter, they will start to, talk differently. And since this man was not seen there, how can we say he was the one that did it? Since the bicycle stolen was not found with him, how can we say that he's the one that did it? So you discover that the proof beyond reasonable doubt is not, like we said, something that comes from the moon, but is evidence that must be able to be adduced by the prosecution to cover all the elements of the offense charge. And then again, where there is a probability, just a mere probability, that this person might have committed the offense or he might not have committed the offense, then it also means that the prosecution has failed to prove his case beyond reasonable doubt. And then finally, I want to talk about on the effect of misplacement of onus of proof. We've talked about the onus of proof in civil matter, talked about the onus of proof in criminal matter. If for any reason the judge misplaces the onus of proof, maybe when A is supposed to be the person discharging the onus, and the court calls on Mr. B to do that, that means that case will fail because something fundamentally wrong has happened to that very case. And then again, proof beyond reasonable doubt does not need the assistance of the judge because it is the prosecution that must prove it. The judge cannot maybe use his wisdom or past knowledge of the defendant to bring to play to say, what are you trying? Why are you trying to deny this? I know you. Why are you trying to deny this? When anything like that happens, then the prosecution has failed to prove his case beyond reasonable doubt. So far, so good, gentlemen. Thank you for coming on board today. So we fix another day to continue our lecture. Thank you very much.